Is it possible to face personal bankruptcy for company debts? Limited company directors are protected from being held personally liable for company debts or being made bankrupt by a form of legal protection known as limited liability. The only exceptions are if you signed a personal guarantee or you are found guilty of director misconduct. Setting up a limited company offers protection from personal liability as a director in most circumstances, and should your business fail, your liability will be limited to the amount of money you put into the company. There are circumstances in which the threat of director bankruptcy becomes a real possibility, however, when your company enters insolvency. If your creditors suffer a material financial loss and you are found to have acted wrongfully as a director, or fraudulent activity is proven, the courts may decide to make you personally liable for some or all of the company's debts. Cash flow problems are usually the first sign that your company is struggling, and it is at this early stage that you should seek professional advice. It is often the case that directors attempt to trade their way out of difficulty in this situation, which is understandable, but this can create a huge problem. It is a legal obligation to cease trading as soon as you suspect your company is insolvent or is likely to become insolvent in the near future. Failing to do so could result in disqualification as a director, personal liability, and potential bankruptcy. Personal guarantees and director bankruptcy. Many lenders insist that directors provide a personal guarantee before they allow a company to borrow. This significantly reduces the lender's risk, but puts directors in serious danger of bankruptcy should the company fail, as they become personally liable for repayment of the loan. If you are unable to repay, the lender can force you into bankruptcy, putting at risk your home and other personal assets. Overdrawn director's loan account. It is common practice for directors to withdraw money from their company on a temporary basis, which is fine when the business is profitable. If your company enters insolvency, however, and your director's loan account is overdrawn, the liquidator will pursue you for repayment in order to increase returns for the creditors. This can result in a difficult financial situation if you do not have the funds to repay. As with the personal guarantees mentioned, it leaves you exposed to the threat of bankruptcy, as you must pay back the money you have extracted from the company. Sole traders more at risk of bankruptcy than company directors. As a sole trader, you are at a greater overall risk of bankruptcy if your business fails, because unlike a limited company, it is not a separate entity in law. Creditors can pursue you through the courts for money on a personal level, putting your home and other assets at great risk. As a result, you may be forced into bankruptcy or have to declare yourself bankrupt as protection against other creditors. If you are a director worried about personal liability for company debt, please feel free to reach out to a member of the Middlebrooks team today.